Welcome to the 8th in our series of COVID-19 podcasts. The topic of this podcast is the law, looking at its role for encephalitis patients and families and discussing the law in a pandemic world. So I'm absolutely delighted to be joined by Dr. Anne Cassidy from Moore Barlow, a national legal firm who are one of our 4 legal partners. I've known Anne for many years and I'm so pleased that she's agreed to join me for this little chat. So welcome, Anne.
Thank you. Thank you, Ava.
Anne, I want to start by asking you to tell us a little bit about your background, because I understand you're both a medical doctor and a lawyer.
I am. When I was at school, there was an assumption that if you were a girl and good at science, you would be a doctor. And I went along with that. It seemed a perfectly good idea. So I came to London to train at St. Thomas's Hospital. That was wildly exciting because I come from quite a small town, and to be in central London was marvellous. After I qualified, I worked at St. Thomas's and at the Medway Hospital in Kent. Then I decided to change career. So I did some locum jobs to save up to pay for my law training. Went to Manchester Polytechnic, which was enormous fun. Then I came back to London to do my legal apprenticeship at a firm in Westminster. Quite quickly specialised in clinical negligence work. Spent the first half of my legal career advising the NHS, and then 15 years ago now moved to Moore Barlow, where I do work representing patients and their families.
Oh, wow. So I'm curious, what made you decide to move from medicine to the law? What was the catalyst for that?
So there were a number of reasons, all very individual to me, and important to remember this was all a long time ago. I was very young. I was a very junior doctor, so I didn't really have very much perspective. But at my very junior level, I didn't find medicine as interesting or as scientific as I had thought it might be. And then my dad died. He died on a coronary care unit. And in a rather teenage way, even though I was in my early 20s, that caused me to question, what is the point of it all? As I say, quite teenage. And then another element of it was that I wasn't entirely comfortable with the power dynamic. I think things have changed a lot, but in the 1980s, medicine was quite patriarchal, and there was something of, or I felt an assumption, I felt a pressure to be more certain about things with patients than I thought I sensibly could be, given how junior I was and how uncertain so much of life is. And I wasn't at all comfortable with that. So those reasons came together and made me think that I wasn't going to be very happy in medicine, and I needed a different career. So I thought about being a shoemaker, because that was quite a fashionable thing to think about in the 1980s. And I do like making things and I do like shoes. But I read a book about medical law, and then I started to read some of the judgments that were discussed in that book. And I found it very appealing the way that judges use the same quite basic common sense principles in different circumstances to come to fair decisions about things. That felt quite natural and intuitive. And I thought I would be more comfortable in that environment where people have made a system of rules that govern their responsibilities towards each other. And that for me, that might be more fun than being pushed around by heart disease or viruses, and just I'd be more comfortable perhaps in the legal environment.
So I'm guessing from this then, just from talking to you, that you've probably never regretted this move to the law.
No, so it was very strange at first because I missed the practical aspects of medicine. I enjoyed doing minor surgery, and I enjoyed lumbar punctures and chest drains and central lines. And at first it felt very strange just to be sitting and thinking and writing letters. So I missed the practicality of medicine. Other than that, the only serious regret that I've had has been quite recently, at the start of the pandemic. Then it felt very strange not to be on the front line in a hospital. There are 2 other doctors in my team and an ITU sister, and I think we all felt that, because and it sounds a bit cheesy, but you don't forget the kind of the special nature of working in a team in a hospital setting, and it did feel odd, and still does to some extent, not to be in a hospital trying to be useful.
Yeah, I can understand that.
Yeah.
I'm curious, are there any notable cases that you've been involved in, or perhaps one where you felt that you've really made a difference?
I suppose from a purely legal perspective, the most notable case I've been involved in is one called Barlows, in which I acted for the Defendant Health Authority, and we won in the Court of Appeal. I'm not sure people always realise that in medical cases, it's not lawyers saying the treatment fell below a minimum proper standard, which is what negligent means. It's independent doctors who work for the NHS and know exactly how difficult the job is. A lawyer can't bring a claim on a client's behalf unless the medical experts say that no reasonable GP practice, no reasonable hospital team would have done what the defendant did. And if the medical evidence establishes that there are different schools of thought about what it would have been proper to do, and if those schools of thought are reasonable schools of thought, a judge can't choose between them, can't prefer one to another, and so the claim will fail. The importance of the Barlows case was the Court of Appeal and then subsequently the House of Lords confirmed that in the very rare case where medical experts are seeking to defend a school of medical thought that turns out to be illogical when you examine it closely, then it will be the judge rather than the doctors who is entitled to have the last say on the standard of care and whether or not it was appropriate. So that's legally the most significant case I've been involved in, I think. Obviously, every case, in every case, there's a particular satisfaction where you've secured the resources that someone needs to try and get their quality of life back on track after an injury. And I think, so I suppose one of the best things about having done this work for as long as I have is the changes in practice that you see that I think are partly related to the positive effects of litigation and lesson learning in the system. When 10 years ago, when I first started doing encephalitis cases, it would not be uncommon to see a delay of a week or more in starting acyclovir, someone presented with herpes simplex encephalitis. And over the last 10 years, the presentation to treatment interval has got shorter and shorter. Now, thankfully, it's really quite unusual to see any delay of more than 48 hours.
Yeah.
And I think it's perfectly, it's not not overly optimistic to think that that soon claims based on delayed treatment of viral encephalitis will be a thing of the past.
Yeah. I think that's something that we've both witnessed, isn't it, over the the last 2 decades probably.
Yeah.
It's good to have seen those changes in policy and practice, and I think policy and practice is something that we'll come back to a bit later on as well, when I'm going to ask you one or two of my more controversial questions, but along these same lines, we both know solicitors can get a bad rap. They're often lumped in with estate agents, and I'm sorry, Anne, but that's the reality. They can be portrayed sometimes in this almost cartoonish way as ambulance chasers, particularly on TV shows and things. We both know that that's unfair. And some of the most dedicated people that I know, such as yourself, work in the law and are genuinely passionate about helping clients to secure a better future. And as we just discussed, making these very important changes in policy and practice that make a real difference for all the patients and families that follow them. Have you ever had any poor responses to introducing yourself as a lawyer?
Yeah, I mean, almost universally, I'd say, and it was a real shock, because when you introduce yourself as a doctor, you get very positive feedback. So when I first started working as a solicitor, I mean, I was sort of quite proud and enthusiastic about my new profession, and it was quite a shock to encounter such a negative response. Now, obviously, I feel quite strongly that that negative response is misplaced. I suppose there are all sorts of reasons why people don't want to think too carefully about the usefulness of lawyers. But I'm always impressed when people are sort of rational and intellectually honest about the usefulness of having a legal system that tries to keep us all safe according to a rule of law. I think there are vested, sorry, it sounds a bit paranoid, doesn't it? But there are vested interests in trying to dismiss the legal process, to some extent in general, and in particular clinical negligence as being some kind of ambulance chasing, vampire squid type endeavour. But I don't think that's a particularly intellectually honest or sensible perspective. Lawyers are dreadful at trying to displace this perception.
Well, maybe this podcast will displace some of those perceptions. I know how lovely you are, and I know how lovely all of the legal partners that we've chosen to work with are, and that's why we were very careful, and we'll come back to why it's important to choose very carefully when you're choosing legal advocacy. But first of all, I thought, actually, just tell us a little bit about what Moore Barlow does and where their areas of expertise extend to.
So I think we are at the upper end of medium-sized law firms. We act for individuals and for people-led businesses rather than for large companies. And we do work across quite a broad spectrum. So I have colleagues who are specialists in the law relating to schools and charities and employment and family issues. We have a court of protection team and a community care team. My own team works closely with a major trauma team that in turn works closely with NHS major trauma centres. They help people who had life-changing accidents, and they have special emphasis on early rehabilitation to speed recovery and to reduce the call on NHS resources. We have colleagues who know all about buying and selling property of various different types, and about the arrangement of tax and trusts. We have a whole company and commercial department that does work with businesses that I find quite mysterious, in the way I think sometimes they find our work quite mysterious. So we do essentially all the work that you would, all the things you'd expect of a law firm, apart from criminal law.
Well, I touched upon this briefly, but, just to kind of, I guess, set out people's expectations of why we chose to have specific legal partners. And one of the reasons that we chose these 4 legal expert partners was in part, I guess, an attempt on my part and the part of the society to prevent people who'd been affected by encephalitis and their families using what I loosely call, and we will be criticised for, but dial a lawyer. You sometimes, if you sat having your lunch, there was a whole period where I used to sit there and there would be these numbers popping up, dial a lawyer, 0800, what have you, no win, no fee, and things that we'll come back to. But so we often see those. And I think what we want to do is really ensure that we were engaging with legal experts who know what they're doing, whose vast years of experience could best advocate on behalf of people that have been affected by encephalitis and their families in the whole range of legal areas that you've just described. It might be medical negligence, clinical negligence. It might be education. It could be family law, as you described. But what should people, what should someone who's looking for a law firm, what should they look out for? What should they be looking for before hiring a law firm?
So I think clear and down-to-earth communication is really important. And people should be able to get an idea of that from their first approach to a solicitor. There are like objective quality marks that are relevant. Clinical negligence is an area in which there are specialist panel accreditations for individual lawyers. So the Law Society maintains a panel of clinical negligence specialists. People can contact the Law Society and ask about that. And the charity Action Against Medical Accidents also maintains a panel of accredited solicitors. And the possession of a legal aid franchise is a quality mark that shows that a firm has satisfied the legal aid agency that the quality of their work and organisation justifies being allowed to do work with the benefit of public funds. So they're external markers. Obviously, inclusion in a charity's legal panel is a very powerful endorsement. So they're places to start. But then people obviously need to be comfortable with their solicitor. It is a relationship of trust and confidence, and it's a relationship that's going to last for a number of years in a case of any significance. So people need to feel that they're understood, respected by someone who knows what they're doing and who will communicate with them in a way that they're comfortable with. So I would recommend, to some extent, gut instinct, subject to those external quality markers.
Yeah, I think those are important. I'm reading The Secret Barrister at the moment. Mm-hmm. I don't know if you've read it, but I think making sure that you hire the right people to represent you is extremely important. So I'm learning a bit about the law just from reading that book. But Moore Barlow, in particular, along with our other 3 legal partners, have got extensive experience of encephalitis.
Mm-hmm.
Why is that so important when pursuing a legal case involving a niche condition like encephalitis?
So encephalitis, fortunately, not a terribly common condition. So if a firm has a body of cases that they've dealt with, they will know the issues that are going to be involved in demonstrating that that the outcome from the condition is tragically worse than it would have been with treatment of a proper standard. So they will know the experts who can sensibly be instructed to give authoritative opinions. They will understand the medical literature that the experts will be depending on. They can follow the medical literature, which is fast changing, which you will know yourself, Ava, because you contributed to it. If a firm is doing has a track record of encephalitis cases and is acting for a number of clients affected by it, they'll be able to afford to invest the time in attending conferences, so the excellent professional meetings that the Society organises, or last year was a brilliant meeting at the Royal Society of Medicine about the changing interface between neurology and psychiatry. And because our team does a lot of work to which that discussion is relevant, we can go to that, and in any clinical negligence case, understanding of the issues and the ability to present them clearly and to properly assess the arguments that may be on the other side of, as it were, it's that understanding that allows you to know what a good result would be for your client and to achieve it. And the clients that we're dealing with, so their injury is often quite subtle. So it's a different situation from the more obvious one where someone may have lost a leg, lost their sight. So sensitivity to the subtle effects of cognitive and behavioural changes, I think is quite important to properly to present the way in which the outcome of an illness has affected someone and the needs that outcome has generated.
I think that's really important point. It's those hidden disabilities, isn't it, that you're fighting for justice in, and that's often an area where a lot of disagreement can occur. In many cases, a starting point often is to try and encourage people to resolve their medical problems by engaging with their PALS service, which is usually found at their local hospital. But can you just explain briefly how litigation is different to pursuing a complaint via PALS or via a chief executive at a health trust?
Yeah, so we would always encourage people to use the complaints process too. But unfortunately, the bottom line is that if someone has been seriously avoidably injured, and if they need funds to cope with the consequences of that injury, to pay for care, to replace lost income, the only route to securing that funding is through litigation. The complaints procedure, if it is well operated, which in many centres it is, though in others less so, is obviously really important for lessons being learned and practice being improved. But for the individual who's already suffered an injury, it cannot produce any funding to address the problems that injury has caused. That's the basic difference. Yeah,
no, that's important. I think I'd probably be right in saying that many of our members have probably never had calls to speak to a solicitor, and sometimes when we talk to people, sometimes even if they feel that they may have a case, they feel a bit apprehensive. They feel as if it's a bit of a daunting prospect. And so I thought it might be useful to just explore with you a little bit, what can people expect when they call up one of our 4 legal partners? If, for example, they believe that they've got a clinical negligence case, or indeed any other cause for concern. You described the vast areas of law that Moore Barlow's work extends into, so family law, employment issues, or problems with their children's education. When they pick up that phone, what can they expect, Anne?
Well, a friendly and interested response. So I'm well aware that people, or it is said that people feel daunted by the prospect of phoning a solicitor, and I can obviously sympathise with that, but I really would urge them not to be daunted. And I think, for a start, how can it be more daunting to phone a solicitor than the serious illness, for example, that they've just been through? They've already been enormously brave. They've dealt with a life-changing, life-threatening illness. So how bad can phoning the solicitor be? And solicitors are human beings, and we are solicitors because we are interested in using our technical skills to solve problems and help people. Contrary perhaps to popular perceptions, but that is our business, analysing problems and solving them, and by solving them, helping people. So any solicitor will be very pleased to hear from someone who has a problem that they might be able to help with. And they'll be very anxious to understand what the problem is. They won't want to waste a person's time if they can't help. So there should be the first telephone conversation, or the first substantive telephone conversation should produce a discussion where someone feels that they're being asked questions that to define the problem that they've got, and then they're getting feedback which is telling them whether or not what they need is a lawyer, or perhaps it's some other professional that they need. Is it if they need a lawyer, is it this lawyer or is it another lawyer? But they will get a positive response of enthusiastic helpfulness about what is your problem, can we help, and if we can't help, who can? So I sympathise with the idea of it being a daunting prospect, but really people should just overcome that. It's not going to be daunting anymore. In comparison with things they will already have dealt with in their lives, this is not going to be daunting. They will feel better after they've spoken to a lawyer.
Yeah, I think we both know and agree that I think sometimes people are so exhausted, I think, as well, from what they've been through.
Yeah.
That there is anxiety sometimes around, if I pick up the phone to a lawyer, is this going to be another long protracted fight that I just don't have the energy for? But I also think that sometimes there are anxieties around or fears around being asked to pay big money up front. Sometimes that's why people don't pick up the phone. I just wondered if you could talk a little bit about that.
Yes, so that is a complete and total urban myth.
Okay.
Yeah, so again, I sympathise with people's concern, but it is not one that they need have. So I've now been in practice for 30 years, and in that 30 years, I have not once had any argument, concern or discussion with a client about legal costs. As I say, when someone phones a lawyer, the first thing will be the lawyer will want to find out if they can help. And any reputable lawyer will do that work without any obligation and for free. So once the lawyer has worked out whether this is something that they can or that they can indeed help with, then the next issue will be, well, what will the appropriate funding mechanism be? And that will be either legal aid, pre-existing insurance, or a conditional fee agreement, which is what is usually referred to as a no-win, no-fee agreement. Now, none of those methods involve any upfront payment of any kind. In the olden days, we used to ask people who could afford it to pay £50 to get the records, because people holding relevant records were entitled to charge £50 to release copies of them, and we wanted to review the records to make sure that we really could help. And if people could afford it, we would ask them to pay that £50. These days, we don't need to do that because records are now disclosed for free. So then the case goes ahead. If the case is successful and damages are won, then people's legal costs, the bulk of people's legal costs, will be paid by the defendant on top of the damages that have been recovered. In circumstances where there's going to be any extra charge additional to what the defendant is paying towards legal costs, those deductions, those payments out of people's damages will have been explained at the outset in detail, and people will have been updated as the case goes along. So when the end of the case comes, they will not be taken by surprise in circumstances where there are payments to be made out of their damages. There are statutory caps on charges that can be made. Most firms have voluntary caps as well. And the whole process is subject to the oversight of the court. So I would strongly emphasise that there is no financial risk of any kind involved in consulting a clinical negligence solicitor. So people really shouldn't cut off their noses or shoot themselves in the feet if they think they have an issue that a clinical negligence solicitor might be able to help them with. They should simply ask.
Oh, that's really reassuring. I think another area as well, in our experience at the Encephalitis Society, sometimes where there's a bit of misunderstanding, is around the statute of limitations. And I just wondered if you could explain what that is and what people should be aware of.
Yeah. So the starting principle on that is that it's not fair for someone to be faced with a claim years after the event, when they might not have the records or the memories that they need to defend themselves properly, if the person making the claim could reasonably have notified them of it much earlier. So that's the reason that there is a statute of limitations. The other side of that principle of fairness is that if someone has a brain injury, for example, and lacks mental capacity, then it's not fair for there to be any time limit imposed on them, because that would leave them dependent on others who might not be in a situation to provide the assistance that they need if their parents or partner just doesn't realise that legal help would be appropriate. So that's the starting point. Children are deemed not to have capacity. So for children, there is no time limit until they reach their 18th birthday. After that, it is 3 years. So 3 years from the age of 18 and 3 years for adults who have mental capacity. The 3 years start from the date that someone first either suspects or should sensibly have suspected that the injury that they're concerned about is related to the treatment they've received. And the 3 years, what you have to do within the 3 years is to start formal court proceedings by issuing a claim form. Courts have a discretion to set aside the 3-year time limit. That's not an entirely straightforward process, and it's all about the balance of fairness between the claimant and the defendant. So the summary on limitation is that if people think they may wish to pursue a claim, they should take legal advice as early as possible. But if people are concerned about something that happened more than 3 years ago, they shouldn't give up all hope at that point and think there's no point in asking a solicitor. They should still consult, because it may be that the circumstances are such that that one can fairly say the 3 years didn't start at the time that the injury happened, because the knowledge that someone had wasn't sufficient to trigger the 3-year time limit starting.
That's really reassuring to know. One of my other questions, just we're getting towards the end of this podcast now, is you wrote an interesting article with what I consider a slightly controversial title. It was called "How Can You Sue the NHS When It Is Saving the Nation?" And I think that's a question at the moment that will resonate with many people in this pandemic world that we're currently inhabiting. What is your view on this? What really were you saying in this article?
So I'm saying that that our legal system is part of the civilized fabric of our society. In an ideal world, it might be that we would all prefer to have a system of no-fault compensation, where anyone who has an extra difficulty of any kind is fully supported in coping with that difficulty and maximising their quality of life out of our shared funds. But that's a system that would be very expensive to operate, and we have our position in society is that that's too expensive for us. It would involve much higher taxation. So the system that we have says that if you lose your ability to earn your own living and look after, to look after yourself because someone has injured you, then we have the system of redress that in narrowly defined circumstances will entitle you to the money that you need to try and get your life back on track and to put you in the position that you would have been before the injury happened. Now, as it happens, where the injury is the result of medical treatment provided by the NHS, the compensation comes from taxpayer funds. But that is just another element of the arrangements that we've made between us to look after each other and to support each other through difficult times. It's no different from the furlough scheme, from the steps that we're taking in terms of pooling our resources look after everyone in the current crisis, and to keep everyone safe. So again, although on the one hand I can understand the instinctive recoiling from in any way inconveniencing the NHS, which is obviously a jewel in the crown of our arrangements. I've seen the system from all sides. I've been a doctor. I've advised doctors and hospital trusts who have faced claims, and I think every thoughtful person who has been involved in the system is pleased to know that there is this safety net that is there when things go wrong. Everyone, the society's work is helping to prevent things from going wrong. All doctors are responding very positively to the work of the Society and other similar organisations. Lots and lots of different people are making sterling efforts to improve patient safety. But whenever human beings try and do something complicated and keep on, increasing their ambition about what they can achieve from the complicated stuff they're doing, inevitably there are going to be times when things don't go as everyone would have hoped. There'll be system failures. A series of small problems taken together will produce a result that overall just fell below the standard that everyone would want to hold themselves to. And then because it's medicine, from time to time, real people will suffer real injury because of that. And then surely it is a comfort to all involved that we do have this mechanism of our system of civil liability, which says that money will be provided to do what it can do to restore that person to the quality of life that they had before the injury, and to give their family and their loved ones the sense of security that they're safe. If people think about it just in terms of them, their children, their parents, their wife, their partner, their friends, their loved people, I think it becomes difficult to see really that litigation, keeping people safe, learning lessons, trying to do better in future, how can that be a negative thing rather than something that basically we're all pleased and proud that we've got, and that we're going to operate calmly, non-confrontationally, in order to get just sensible, just, safe results that help people. They help the person who's been injured, they help the clinicians who've been trying to help to treat that person, and who very sadly have seen the thing go pear-shaped. Everyone is happier. It's quite it's difficult to see why if people are honest with themselves there's any problem of any kind with that.
Yeah, I think you make some important points, and I think one or two that stood out for me, whilst we all there are bad apples in the world, and bad apple doctors or physicians, or we hear and we see about these random individuals on the news who in some cases have done appalling things, but in most cases these are often, and you used the word, system failures, and I think quite often it's not one individual who's done a bad thing knowingly. That isn't what this is about. This is often, as you said, a whole domino effect of things that went wrong, and an individual was unfortunately injured, and I think that's such an important point for people to remember. And I think also that point that we talked about earlier. You know, when you talk to often, and I'm sure you will have heard it many, many times, Anne, when you talk to patients and families, they'll often say to me, I'm not bothered about the money, I just don't want this to happen to anybody else. And so that comes to the important point that we touched upon earlier about litigation being able to influence changes in policy and practice. So I think that's important.
Yes, I think it is part, it is one of the ways in which lessons are learned. It's one of the driving forces. We always, so we as claimant representatives, we make it as clear as we possibly can where we think the problem's arisen. We interact with other organisations like the healthcare safety investigation branch to try and extrapolate from the local lesson of our individual case to a more general lesson that can be learned to keep people safe. The same happens on the defendant side of the debate, as it were. NHS Resolution is looking at circumstances that have led to litigation and doing its best to feed back to trusts about areas where systems are weak and can be improved. Money is something that is noticed by people, and so an expensive litigation is a driver to change. I mean, obviously it's much better if lessons can be learned without any expense being incurred. But in the real world, people are a lot better, for example, at interpreting CTG traces during labour than they used to be, and unfortunately, it is the cost of obstetric brain injury cases, I think, as much as the fact that children are brain injured, that has driven that improvement in practice. So we're all part of a jigsaw, different skills, different perspectives that fit together, but with the same aim of making things better. And it is not sensible to demonize any part of the system or to be confrontational about things. We just need to be working together, each playing our roles in this knitted together system properly and fairly, and gradually, step by step, improving things.
Well, absolutely. I think those are very sensible words on which to begin to bring this interview to a close. I've been absolutely fascinated to talk to you over the last hour. But before I do draw it to a close with some final comments from me, is there anything else that you'd like viewers of this podcast to know, or that you'd like to say before we finish up?
No, I feel as if I've said lots and lots of things and rambled on a lot. So I think lawyers are just dreadful at conveying it, but I would like people to, if they possibly can, just to take a leap of faith and believe that lawyers are not terrifying, they're not vampire squids, and there are circumstances in which we are exactly the people who can provide practical help, and we're good at identifying those circumstances, and where we can help, we really want to. So take a leap of faith. Hopefully you don't have a problem that might need a lawyer, but if you do, just engage with one, and perhaps the problem will then be shared and solved.
That feels like wise words to finish on, taking a leap of faith. Well, look, we're deeply grateful to you for taking the time out to speak to me. I know how very busy you are. Thank you so much for the many encephalitis cases that you've handled over the years. I know that most of them never end trial. It's always sorted out before, which I think is a relief for the patients and their families. We do want to reassure any viewers that the Encephalitis Society services continue unaffected during this challenging time. So if you need any support or information, our teams remain at your service. Please go to encephalitis.info for contact details or to chat online. And if you want any more information around accessing any of our 4 legal partners or any legal information, then go to encephalitis.info/legal-advice. And if you've enjoyed this podcast and you can support our work during this difficult time, then it's encephalitis.info/donate. Just for me to finish up and just to say thank you again, Anne, and stay safe, everybody.